Welcome on behalf of the Syracuse Builders Exchange. We wanted to provide you all with some high-level updates with regard to the coronavirus and specifically how it relates to the construction industry. So today, on behalf of the Syracuse Builders Exchange, we wanted to push this content out to you. We have speakers and representatives from One Group as well as Sheets and Bailey. And today, the items we're going to be discussing, this is primarily for informational and educational use. Nothing in this discussion should be considered legal advice. So we would ask that you please consult with appropriate attorneys or your other advisors before addressing any situations relative to the items we discuss. On the splash screen or splash page on your screen, there is a longer disclaimer we would ask that you read. But we did want to push this content out to you. And we understand that this information is changing by the hour, and we appreciate your time and attention. So today, we're going to be covering a number of topics. First, we will have Jason Bailey, a partner at Sheets and Bailey, discussing contractual risk. I, Adam Brown, am a Senior Vice President at One Group. I will be discussing insurance coverage, exclusions, and endorsements. And then we have Kelly Goodsell, who is a Vice President of our Claims Department at One Group, discussing claims, and Paul Kader, who is a Vice President of Risk Management Services at One Group, will be addressing safety and the health of workers. So thank you for your time and attention today. And with that, Jason, I will transition the discussion to you.
All right, thank you. Good afternoon, everyone. It's about a little after 2 o'clock on the 27th. I suspect that many of you that will be listening to this next week are actually listening to the Syracuse Builders Exchange webinar right now on New York State's updated guidance as of earlier this morning. So please keep in mind the timing of this and that the advice may change, not drastically, but it may change slightly based on the new guidance. With that out of the way, let me jump into some of the things that you all need to be considering with the present state of affairs. Contract risk. So I'm presuming that most, if not all of you, have reviewed contracts relative to your particular projects in the past, or have people that do that for you and provide you with updates. I'm going to go through a few of the typical requirements in some of those contracts and try to flag a few things for you so that you can be mindful and protect yourself going forward. So the first general topic that I want to hit is injury and damage to property. So as you may have noticed over the last 5 to 6 years, the classic indemnification clause that says that you will protect the upline contractor or owner from claims relating to personal injury or property damage have been expanded greatly. They've been expanded greatly in 2 ways. One, they primarily don't relate to just property damage or personal injury, but the indemnification clauses that are being used in custom drafted contracts expand well beyond that. Additionally, they expand to try to force you to indemnify them beyond what the state of New York allows. In New York, unlike many other states, you cannot be required to indemnify someone for their own negligence. In other words, if a general contractor is solely responsible for property damage or personal injury to someone else on the project site, they cannot force a subcontractor via an indemnification clause to actually indemnify the general contractor. If liability is spread out among several parties, then your indemnification clause can come into play. But just keep in mind, if your indemnification clause stretches beyond liability that you have in fact caused, you can't be held liable for that. So just be mindful of that. Second quick point under injury and damage to property that I want to hit on is the insurance requirements in general. We spend a lot of time focusing on project delivery in the vertical integration of the contract requirements from the owner all the way down to the last subcontractor. In other words, what the general contractor owes to the owner, the general contractor wants to make sure that its direct line first tier subcontractors owe to the general contractor, and second tier subs owe the same responsibilities and requirements to the first tier subcontractor. In other words, everyone, no matter where they are in the hierarchy, are on the hook for the same obligations. There are no loopholes. There's nothing missing in those requirements. You want to make sure that your insurance requirements, what you require a sub to provide, mimics what you have to provide to the owner. The other quick point on injury and on damage to property that I want to hit on is with respect to OSIP and CSIP projects. We have noticed that the notice requirements, the obligation to put someone on notice in the OSIP and CSIP projects is much more strict than, say, your traditional projects. In these instances, if you fail to provide notice in accordance with the CSIP and OSIP programs, you will potentially forever lose your right to make a claim. So just be mindful of that. Read your documents. I can't tell you how many times I tell clients, read the contract, read the requirements, read the fine print. Know that you're on the hook for all of that. So shifting gears really quickly, because we're all trying to be brief and give the listeners a view from 40,000 feet, if you will. I want to shift over to payment situations. And the whole reason you're doing your job is so you can get paid. And unfortunately in New York, fortunately for some, the courts of New York over the last 2.5 to 3 years have started strictly enforcing notice provisions in contracts. What do I mean by that? Well, if you incur an extra cost, you recognize that there is an ambiguity in the plans and specs that calls for you to do work outside of your scope, your contracted scope, you have an obligation to put the upline contractor owner on notice. And your failure to provide that notice per the contract can lead to you forever waiving your rights. Those clauses are now being strictly enforced. So you need to not only find the clauses that say when you have to provide notice, you should also look in your contract to see if it dictates to whom you have to send the notice and the form you have to send it in. In other words, does it have to be sent via email? Certified return receipt requested? Does it have to be sent by both? Read the contract as to the notice provisions and comply with every aspect of it. And what I often find is that clients recognize that they have incurred or will incur additional work outside of what they contracted for. They'll request a change order or they'll submit a claim notice. And more often than not, they fail to request an extension of time at the same time. So in other words, if you were only supposed to supply 100 widgets to the job and suddenly realized at some point in time that you have to supply 150, the supply of the 50 is easily quantifiable, but the installation of that 50 may take 50% more time. It may only take 10% more time. We are finding routinely that clients fail in those instances to request an extension of time. In today's present climate, I can assure you that the vast majority of general contractors and subcontractors are going to incur delays on projects, delays that they have no control over. You need to look at your contracts to find out what the notice requirements are for seeking a time extension. Many times there will be clauses specific to time itself, but you may also have a clause, it's called force majeure. It is very commonly found in AIA contracts, specifically in the general conditions. If you have a custom-made contract, it may not be in there. But if you have a force majeure clause, you should reference it whenever asking for more time in today's climate. Why? Because that clause is commonly referred to as the act of God clause. It essentially says, if you are delayed, if the project is shut down, if you need additional time because of some event that you had zero control over, like the coronavirus, uh, you have certain relief that you can request. So please take a look at those clauses. Look specifically for the force majeure clause. If it's not there, then simply look for your time extension clauses and make sure you give notice per that clause. The same for money, additional work. Not only additional work, but as you guys all know, that come June or July, the rates on prevailing rate jobs are going to increase. Depending on how long this delay is, you may have anticipated completing a job before those rates change, and now that the job may be completed long after those rates change. So keep those things in mind. Look through your contract and try to put people on notice as soon as possible and with as much information as possible. To the extent that you cannot quantify the delay or the potential impact, please note that in your notice. The last thing I will say quickly is, with respect to payment, is look at your releases very closely. At one time, it was common for releases to simply say you're releasing all of your lien rights, claim rights with respect to this sum of money that you're about to be paid. Some lien releases have changed to say you are releasing all of your lien rights and rights to make claims from the first day in time up until the day you sign it. But what happens if a month before you perform some extra work and haven't been given a change order, and as such you haven't been able to incorporate that request, that additional compensation in your payment applications? You may have just waived your rights by signing a lien release that is tied to a date versus a sum of money that is to be paid. So pay attention, read your lien releases carefully, make sure you're only giving up what you're being paid for and nothing else. Lastly, because I'm already running over by a minute, I want to quickly reference flow down clauses. You will often see in your contracts a reference that the contract above you is incorporated herein. And many times that will be relied upon to get you to do things that you wouldn't think you otherwise have to do. Let me tell you right now that if a flow down clause is generic and simply says the prime contract or any and all contracts above this contract are incorporated herein, the entirety of that contract is not, I repeat, not incorporated into your contract. Only the provisions that pertain to scope, quality, character, and manner of the work are incorporated. In other words, the specs, the plans, how you go about building the thing that you're building. Provisions such as dispute resolution, arbitration, are not automatically incorporated into your contract. So please be mindful of that. Look to see what type of flow down clause, if any, you have in your contract and be guided accordingly. Thanks.
Jason, thank you very much. A lot of good information there, and a couple of key themes that we're going to hear throughout the different discussions. My name is Adam Brown. I'm a senior vice president with One Group, specialized in insurance coverage, and I did just want to touch upon what we've learned over the last few weeks in addressing this pandemic. I'm sure all of you have been made aware so far that relative to insurance coverage, business interruption policies typically require that there be a direct physical loss of or damage to the property that you are insuring. And in order for coverage to be triggered, there needs to be a covered cause of loss. And a lot of the claims and losses that our policyholders and businesses that we represent are likely going to be seeing are going to be a direct result of economic loss. So that being said, the insurance policies that everyone has in place for business interruption really aren't intended to cover a pandemic like this. There may be some rare, and I would stress rare circumstances where coverage could be picked up. Kelly Goodsell is going to touch upon claims, and we'll talk about workers' compensation. That's one area that coverage may be applied, and also possibly directors and officers liability. There may be some rare circumstances where liability claims could be picked up under a D&O policy. The one thing we would encourage you to do, though, if you do have specific circumstances and specific questions, reach out to your representative, have the conversation. Insurance carriers are very unlikely and unwilling to give you an opinion on coverage until you submit a claim, typically. But we have seen some insurance carriers proactively reach out to customers in advance of claims being submitted with regard to this specific instance. There are a handful of insurance companies that I'm aware of that have sent letters to clients basically giving them a coverage determination in advance of submitting a claim. But I wanted to provide you all with just a brief update as to what we're seeing in the market. Right now, as I'm sure you can imagine, the insurance marketplace is in a state of flux. We have continued to have discussions with our carrier partners, just like all the businesses that are affected by this pandemic, they are too. A lot of their employees are working remotely. The one thing, or one of the things they have shared with us and in our daily routine and working is that they are open for communication. They are processing claims. They have been addressing questions, issuing endorsements, processing renewals. They're very much still there and available and open for business. The other key message we're hearing from them, because this does affect every single business that we're aware of, is that they are going to remain flexible. Some of them have put holds and moratoriums on issuing cancellations for non-payment of premium. Some have positioned themselves and put holds on any non-renewals. They may have, some carriers had issued non-renewal notices for certain policyholders. As a result of this, they're just saying time out. We're going to keep coverage in place, and they're going to kick the can down the road. We're also experiencing a pretty high degree of flexibility when it comes to audits. We've had some clients that their policies just renewed, their old ones just expired, and now all of a sudden they may have an audit payment. Well, the carriers more or less are saying that they'll be flexible with those. They'll give special terms and conditions in financing that. The other thing is they remain flexible in modifying policies midterm. As you know, a lot of your general liability policies and workers' compensation policies are, the premiums are based upon exposure projections in the area of sales and payroll. And as a result of what's going on with COVID-19, those projections could shift. So the carriers are open to modifying the premium midterm, or excuse me, the exposures and the rating basis midterm. So you can adjust your payrolls down, you can adjust your sales down. The other thing that some of them are willing to do is they're willing to put you on a pay-as-you-go program. One carrier basically said, we'll tie your workers' compensation premium to what your actual payroll is. It's very rare for them to make these modifications midterm, but because of the effects of this pandemic, they're willing, open, and available to make those changes. But the key thing is, in tying into Jason's message, it comes down to communication. You can't just assume that the carriers are going to make these accommodations. You really need to communicate to your broker, communicate to the carrier what your individual circumstances are, and allow them to make the needed modifications that are going to assist you in your business and your employees through this challenging and difficult time. As we stated in the beginning of this, there is new information that is posted and available every hour, every day. So by the time this information gets to you, there may be new information that is available, but we're committed to continuing to push out content and keeping the communication and the dialogue open with you all. So relative to the insurance, that's all I had. There will be more to come, but what I would like to do now is transition the discussion over to Kelly Goodsell, who is a vice president here in our Claim and Risk Management Department of One Group, and Kelly is going to chat with you a little bit about claims. Kelly, go ahead.
Good afternoon. Thank you. And I'm just going to reiterate a few things that Adam had touched on as well. A lot of the claim questions that we're receiving in our agency is, my business, we had to shut down. Do I have coverage for, having to close my restaurant? I'll just use that as an example. The other questions that we're receiving is if my employee contracts the virus, the COVID-19 virus, will workers' compensation cover my employees if they are to contract us? So I'll tackle them in separate matters. So with respect to, my business is shut down, or does my policy even have business interruption coverage? So as Adam had mentioned, the intention of the business interruption coverage portion of the policy is not intended to cover an economic loss without an actual covered cause of loss. So again, I would encourage you, if that is one of your questions that you're also pondering, reach out to your broker representative, review your policy with them. Most policies very specifically have an exclusion for a virus and a bacteria that would not afford coverage. So again, it's very important that you read your entire document and do that with either your legal representative or your broker representative. There are a few policies out there that do afford coverage for a contamination with a sublimit, but that is not relevant to the business interruption, the economic. It affords coverage for what I would refer to as the cost for the decontamination. So you actually have to have evidence and proof of the bacteria being in your workplace to afford that coverage if in fact you have it on your property policy. There are some policies that do exist out there that do have an endorsement that would afford coverage for communicable disease. Again, that's not the standard. So I would encourage you again to review your specific policy. I will also mention that the Department of Financial Services has advised all the property and casualty insurance carriers to post on their websites their position when it comes to coverage and how their coverage would respond to COVID-19. So again, that's another resource if you want to look at the carriers' websites as well. They should have that posted. With respect to workers' compensation, this is a little bit different with respect to there actually could be coverage afforded when it comes to workers' compensation. But I will just tell you that for an injury or an occupational disease to be covered by a workers' compensation policy, the loss to the employee must have arisen from the direct course of the employment, which may be difficult to determine an event such as a virus outbreak. An infectious disease like COVID-19 and the common cold are not typically found to be work-related. Medical evidence that the injury or illness was work-related must be presented to establish compensability. Should you have an employee who has contracted COVID-19, I would encourage you to report that to your workers' compensation carrier. They will investigate it like they would any other workers' compensation claim. And basically, it's going to come down to the medical evidence that the employee contracted the virus from in the course of their employment, their job responsibilities. So with that, I think from a claims perspective, those are the two issues that we're dealing with mostly on a day-to-day basis. So with that, I guess I will forward it over to Paul Kader, who is our Vice President of Risk Management at One Group.
Thanks, Kelly. Some really good information coming out and things that interrelate among the different topics that you're hearing, how one affects the other. From a safety and hygiene standpoint, it's the same thing. The things going on out on the job sites right now are different from what we've faced in any other time. However, as we look at the safety aspects of the job, OSHA is actually treating the exposures associated with COVID-19 as they would any other exposure. They're incorporating the evaluation and assessment of the COVID-19 problem within the standards that they've already written. So they're not issuing any new standards relative to this exposure. So we have to keep that in mind as we move forward on this. OSHA has issued a very good guidance document that is available on their website. Just search COVID-19 guidance document OSHA, and you'll be able to pull that down. That gives some good step-by-step guidelines as far as how to assess the exposure that your employees face on a day-to-day basis, which can in turn be used to develop your on-site control programs. You're still required, whether it's a specific standard or not, you're still falling under that general duty clause that says that you must provide a safe place to work. And that's where a lot of changes, a lot of different things that we might not have done in the past will have to do today on the construction sites. Things like putting in more hygiene stations or maintaining the hygiene stations to facilitate more use. Plenty of soap and water on sites, hand sanitizer on sites, wipe downs on sites. Thinking of any place on your job sites that there is physical contact with tools, surfaces, etc. So making sure that we have the hygiene facilities there to suffice. These things will vary slightly in different types of construction exposures. If you're working within healthcare facilities, which is considered in the new essential businesses. In healthcare facilities, you're going to be falling not only under the general, the construction rules, but you're going to be falling under the Department of Health rules, and those have gotten much tighter relative to hygiene and PPE within a healthcare facility. And you may be working in one of those areas. And you have to look at these exposures and these controls and think about what you're actually dealing with and really take it to heart and apply them. You're going to have your feet held to the fire to them, but you also have to look at what the potential is if we don't adhere to these controls. The other areas that you have to look at, besides things like hygiene stations, are training. Training is essential for all employees relative to the exposure to COVID-19, relative to the reporting requirements, relative to hygiene and everything else. The PPE that you have to use may be different from what you've used in the past on any given job, so employees have to be briefed on the PPE exposures and PPE usage relative to a given job in a COVID-19 positive area. In this regard, you also have to adhere to the PPE program requirements as far as assessments and whatnot. The other thing is general maintenance and housekeeping on the job site. The COVID-19 specific controls deal with touch points and touch surfaces. So you'll have to look at how you're maintaining your job site on a day-to-day basis. And then the key thing that we've all been hearing from every day from the start of this thing is a social distancing issue. That actually did have a big impact in the decision by the governor relative to the essential business changes. The other thing is I want to talk to you about working on someone else's site or in someone else's project or in someone else's building. There is a need during this crisis for sharing of information between contractor and owner and GC and sub and everything else as far as what's going on, what's being done on site, who's there, how often they're there, what the crowd situation, the density of the population is going to be, and in certain situations, whether or not there's been an exposure or a positive test result relative to COVID-19. That information must be shared. The health department in that given area, if there is a positive test, will be doing a formal investigation to find out who was in close proximity to anyone who tested positive, and we'll be talking to those individuals and discussing things like quarantine and whatnot. So you have to maintain good awareness of where everybody is, where they were on a given day, and you have to respond to the sharing of information. Lastly, when you do have certain issues that occur, if there's a positive test or response to a potential exposure, you want to make sure that you understand and follow the CDC recommendations for hygiene, for clean down, for disinfection of the given areas. And as I said before, if there is a positive test, the health department will be investigating. And that's not a negative investigation. That's an investigation saying this individual tested positive for COVID-19. We want to know who that individual was in close proximity to. The other aspect of that, though, is when there is information on a potential exposure or even a positive exposure, you have to keep in mind the HIPAA value of the information as far as sharing names and things like that. I would strongly recommend that you touch base with your legal counsel or your broker or the association to talk about, hey, what can I release? What should I release? Who do I have to tell these things to? And what information do I have to tell? All these things that are happening today, you know, are going to come back sometime later and be reevaluated, whether it's in court or under a claim. So as you're going through that, think about what's going on your site. I want to give you just a few good resources that you should be visiting on a day-to-day basis just to keep in touch. I do recommend if you're doing business in New York State, stay in touch with the governor's office as far as the information he releases every morning. He's a wealth of information, and you can see how quickly the requirements and operational changes are taking place. But in addition to that, go on to the CDC, the Centers for Disease Control site. They provide very, very good information, and if you drill down into the site far enough, you're going to find step-by-step instructions for what you need to do to clean or what you need to do to disinfect or report or whatever the case is. That's a wealth of information. OSHA put out that guidance document. That should be more or less in everybody's truck at any given time just to look at and build your program around. These are the things we need to do to protect our employees. For information about technical issues, if you're interested in the therapeutic process or the vaccine process or anything along those lines, as well as how contagious this virus is or how much it will stay on a given surface at any given time, go to the National Institutes of Health website. And all these are cdc.com, nih.com, et cetera. A good site for detailed information on what you need to do in specific industries is the New York State Department of Health website. If you're working in a healthcare setting or if you're working in a food manufacturing or food service setting, they have very specific requirements as far as cleaning and sanitation within those areas. Also, touch base or stay involved with your association, the Builders Exchange and others. Keep in touch with your insurance broker. We have one group, we're on the phone constantly answering questions of our clients from 8 o'clock in the morning to 10 o'clock at night. And don't forget your legal counsel. All this is shaking out, and sooner or later somebody's going to sue somebody, so you want to make sure that you have good contact with your legal counsel throughout this process. So from a safety and hygiene standpoint, in general, you want to make sure that you recognize that all of the standard OSHA requirements are in place, only you have to include the COVID exposure into how you apply those. So with that, I'll turn it back to Adam and we can wrap up and close. Thank you very much for your time.
Thank you, Paul. And certainly, you know, we're all committed to being here for you and serving you in this time of need. Things are going to continue to develop. Questions are going to continue to be raised. One group, Syracuse Builders Exchange, and the team at Sheets and Bailey are here with any questions or needs you may have. And certainly, we would ask that you reach out, and we will continue to push out content as it's updated and as it becomes available. So with that, have a great day, and thank you for spending your time with us this afternoon.